3, 2, 1. Welcome everybody, also in the name of Professor Hanschel. I'd like to welcome all of you to our next Law After Lunch presentation. We have an African block, so to speak, if I may say. We are fortunate and happy to have currently two colleagues from Ethiopia with us, and you know probably Fike Marcos Merzo-Berhanu, who is teaching here with us, and I'd like to introduce today to you Marta Hailu, who is not the first time in Halle, but I don't know, fourth or something like that, at least. Marta is a PhD student with me, and she is working at the Faculty of Law in Addis, at Addis Ababa University, and researching on movement of persons, namely in general, but also with regard to labor mobility in the African context. There are very fascinating, interesting developments. You might know, all of you, that when was it? I forgot, last week? When was the signing procedure of the free trade agreement? Last week, I believe, was it? Or not?
Signing?
Yeah, the signing of the free trade agreement.
Like by who? I mean, in general, it was ratified like by 25 countries.
Yeah.
So it came into force last month.
It was last month. Yeah, it was last month. And that is, so there are interesting developments in terms of economic integration in Africa, and part of that is, of course, the movement of persons. And we will learn about that. I'm very happy to have you here, Marta. It's good to see each other again, and we are very much looking forward to your presentation. You have the floor.
Thank you, Professor CJ. Thank you, colleagues. So my presentation is on the currently or recently concluded protocol on movement of persons. The protocol was concluded as part of the African Economic Community under the African Union. So my question is, how far can this protocol ensure mobility of Africans within the African border? So to talk about that, first let's have a background on the integration process in Africa in general, and then I'll look at how what the progress looks like in terms of the formation of the African Continental Free Trade Area. And then we have also a new, so to speak, a new aspirational document which says Agenda 2063. What do we want to have as an Africa in by the year 2063? And then I'll come to the protocol in particular. So coming to the background, there are a number of initiatives under Africa, the formerly Organization of African Union, and Unity now African Union, to have in the regional as well as continental-wide integration. And so we have at the continental level, there were efforts, at least in terms of the charter of the OAU, it aims at coordinating and harmonizing economic policies. And then in 1980, we have this leg of this plan of action which aspires at creating an African common market by the year 2000. But that was not possible, so another agreement was signed in 1994, that's the Abuja Treaty, which aims at forming the African Economic Community by the year 2028. Of course, through the different levels of or stages of integration process. And then at the regional level, we have different smaller groupings. The African Union recognized 8 of those regional economic communities as building blocks for the integration. So coming to how the African Economic Community is supposed to be achieved, we have, as I said, 6 stages of integration. Between 1994 and 2000, the idea was to strengthen the already existing regional economic groups, and then followed by coordination and harmonization processes, progressive elimination of tariff and non-tariff barriers to be achieved by the year 2007. And stage 3 was the establishment of different free trade areas within the regional economic community groups, and of course customs unions by the year 2017. And then that FTA would change into customs union. So after a few years, we'll have an African common market. And then by the year 2028, the idea was to have the consolidation of all those smaller groupings and making them one economic community. So to form this African economic community composed of all those 55 currently countries, it means those smaller groups need to complete their level of integration. But only a few of them were progressing in terms of the time framework that was provided in the treaty. So what was proposed in 2012 was that we need to fast track the formation of a continental-wide free trade area. And this continental free trade area aims or wants to use originally those recognized regional economic communities as springboard for at least like we have on the eastern and northern part, we have the COMESA, EAC, SADC, so that would form one part or one pole of integration, and that would inspire the other part of the continent to form a similar kind of arrangement. So we'll have a second pole of integration, and then ultimately they would merge into one to form one single community. But that was not achieved because the progress of forming the tripartite free trade area between COMESA, EAC, and SADC was not successful. So in 2015, they have decided that let's negotiate on a country-by-country basis. So in 2015, the negotiation was launched to each of those 55 countries to negotiate to form the free trade area. That was somehow success in that the agreement was adopted and it was open for signature in 2018. Together with that agreement, the framework agreement, were 3 protocols: protocol on trading goods and services, and protocol on the settlement of dispute. So all those were signed. These are a kind of a single undertaking. They came together with the framework agreement. When the agreement was opened for signature, about 44 countries signed immediately, and then subsequently other additional countries have signed, and so far only 3 countries are outside of this agreement. That's Benin, Eritrea, and Nigeria. It's said recently that Nigeria would sign the agreement in the upcoming summit, which is going to take place after 2 or 3 days. The agreement needs 22 ratification to enter into force. That was obtained in April. So this is historical document in a sense that it's the first African Union document to get the required number of ratification within about a year, as opposed to others which require mainly, or which took rather about 5 years. Ethiopia is one of the countries that has ratified this agreement. So the agreement has entered into force as of May 30, 2019. But of course, as far as the other, when we talk about implementing this agreement, we need to have specific schedules of commitment for the services, and also in terms of the trading goods. Those things are still an ongoing negotiations. So as far as movement of persons is concerned, and my interest is on the protocol on trading services, with regard to the CFTA. So we have some things which are provided under the services protocol. just like in the WTO agreement, there are 4 modes of service delivery. The 4th mode is movement of natural persons. So there are many barriers to services providers within the African countries. So what would happen in terms of specific commitments is something that we would see when the schedule is finalized. And so again, coming back to this movement of persons, another important document would be the Agenda 2063, or what we call the Africa we want. It's a vision document which was adopted on the 50th anniversary of the African Union. So it outlines the aspirational development goals of the African Union for the next 50 years. For specifically aspiration number 2 has relation with movement of persons and trade and so on. So we have the targets. The aspiration is to establish a united Africa, fast-tracking the Continental Free Trade Area, improving connectivity, and so on. So the targets are some of the targets, abolishing or waiving the visa requirement for intra-Africa mobility by the year 2018, ensuring that the protocols on free movement of persons and goods would be domesticated by the year 2023, and having an African passport by the year 2025. Of course, African Court of Justice would be put in place by 2013, and so on. So when you look into the responses of different countries vis-a-vis those targets, there are some encouraging signs. Like, for example, some countries have started to somehow issue visas on arrivals, like Benin, Rwanda, Ghana, Mauritius, Seychelles, Kenya, and Ethiopia are those countries who give visa on arrival for other African countries. So when you look at the visa openness index in 2018, it reports that there's a slight improvement in many of the African countries, and I believe it's a contribution of those efforts. As far as the African passport is concerned, yes, there was an idea of forming African citizenship and African passport since 2004. But of course that became kind of a reality when in 2015 the leaders declared that we'll have an African passport by a certain date. So in 2016, a common electronic biometric African passport was launched, and 2 of the African presidents were the first ones to get this passport. Later on, some other foreign ministers and so on, and prominent African business persons were also issued with this passport. But as far as ordinary citizens are concerned, we still do not have that passport. But the idea is that the holders of this passport would be able to travel within African borders without any visa requirement. So how far has that synced within the officials, within the states, is of course something that we need to work on. Like in one of the recent interviews of a Nigerian business person, he's one of the biggest investors in Africa, Aliko Dangote. He said that I went to South Africa using the African Union passport. It was okay. But when I travel to Angola, I have to be given a visa on the African Union passport. He said, I did that deliberately. When I was asked to apply for a visa, I gave them the African Union passport to test them. And then they issued a visa on that. So if you say the goal is to have, to allow the holders of the African Union passport entry without any visa and so on, then we should also inform the officials and so on of this goal. And another document which was signed together with the Continental Free Trade Area Agreement was the Protocol on Free Movement of Persons. The two are separate in a sense. The agreement establishing the CFTA is a different document, and the protocol is part of the treaty which was signed in 1994. The treaty which establishes which aspires to establish the African Economic Community. Under Article 34 says that a protocol on the free movement of persons would be subsequently concluded between the parties. So it took more than 10 years to have that. And the protocol was, as I said, opened for signature on that day, but only 32 African countries have signed it. It needs 15 ratifications for its entry into force, but only one country, that's Rwanda, has so far ratified that document. So despite this, assuming that it gets the required number of ratifications, let's see what it has in store for us. The objectives, when you look at the objective of the protocol, it has the progressive implementation of different ways of interest, like free movement of persons would be at the first phase, right of entry and abolition of visa requirements to African travelers. The second phase would be right of residence, and the third phase would be right of establishment. So let's look at each of the protocol is a very brief document. It's not detailed. It does not have detailed rules. As far as entry is concerned, what is recognized in the document is that there's going to be an entry through a designated point of entry using a valid travel document. It can be the African Union passport when it is issued. And you can enter without a visa and stay up to a period of 90 days. But these things can be done in accordance with the laws of the host state. And there are also some grounds for refusing entry: national security, public order, public health, plus other conditions may also be introduced by the host state sometime in the future. So when you look at the protocol has also a roadmap for implementation, which was adopted by the states. So by December 2018, to have a relaxed visa regimes and have clear, consistent, and transparent admission criteria. I just selected few of those targets. And by 2019, to have a regional passport. By 2023, complete abolition of visa for travelers within African travelers within Africa. When you look at, like, in terms of the successes of those things, relaxed visa regimes by 2018, only few countries have managed to do that. Having a regional passport, only two of the regional economic communities, the East African Community and ECOWAS, use regional passports, and that's even because of their own treaty, which mandates for the formation of, for having regional passports. And then we have also rules, or just two or one for each provisions on students and researchers and workers, so that they can move from one country to another country for purpose of education, purpose of research, or to take up employment. But those things can be done only in accordance with the law. So repeatedly in each of those rights, what we have is a phrase, an addition, which says this can be done in accordance with the law of the host state. We come to the other rights, right of residence and right of establishment. Even the definition, when you go back to the first parts of the protocol and look at the definitions, they want to make sure that how we define residence is to be done in accordance with the laws of the host country. It's written in bold and in underlined to indicate that their laws would have a prevalence over whatever is going to be concluded as under the protocol. These are some things. Right of residence and right of establishment are some things to be achieved sometime in the future, so we don't find a concrete kind of time framework for when to achieve those things. So I have one question, like in terms of this, the relevance of the phrase which says in accordance with the laws of the host member and member state. As I've said earlier, The protocol is part of the Abuja Treaty. The Abuja Treaty established or aspires to establish an African Economic Community, which is a legal entity or an entity with legal personality. Yes, the legal personality is not provided specifically in the treaty, but we can infer its legal personality by looking into other cases. And under Article 3, paragraph E of that treaty, it specifically says that or indirectly rather, indicates that it forms a legal system. When it says that countries have to have an obligation to observe the legal system of the community. So that means the AAC is a legal entity with a personality, its own personality, and has or is a legal system. But what happens? How is the laws of this community going to be received within the national legislations of the member states? And what's going to be in terms of the hierarchy of the community law vis-a-vis the national legislations? There is nothing specifically provided in the AAC treaty with regard to those things. So we can look at like different provisions and reach to a conclusion that the AAC has the laws, the treaty itself and other protocols can have direct applicability and can be also superior than or over the national legislations. But we reach there through inference by looking into the different provisions that are provided in the AAC treaty. Like for example, in terms of the direct applicability, Article 10, paragraph 3 and 13, paragraph 3, when they talk about the decisions of the Assembly and the regulations of the Council, it says they are enforceable automatically 30 days after their signature. So we can say, okay, this is directly applicable. We can argue that way. And then with regard to the hierarchy, we can look at Article 5, which mandates member countries to refrain from taking actions which would undermine the objective of the AAC. Plus, there is also a requirement of harmonization, and of course, the previous two provisions that we've talked. I've mentioned, we can conclude that the AAC law is supreme to national legislation, but this is just an argument, one argument. But of course, these issues, direct applicability, hierarchy, and so on, obviously have a lot to do with sovereignty of issues, whether or not the member countries are willing to surrender some part of their sovereignty. In the literature, what I see is that supremacy of law has to be either provided specifically in the state, in the community's legislation, like in the case of the East African community. It specifically says that the EAC legislation is supreme, so any national legislation must be in compliance with the EAC legislation, or alternatively through judicial decisions. It may be held that it's a supreme law. The ACFTA treaty does not provide supremacy, and there is so far no decision, because we don't have the African Court of Justice. What we have is the African Court of Human and People's Rights Justice Court, which is temporarily functioning as a court of justice. But as far as I know, there is no holding of this court about this matter. On the other hand, we have this protocol. Okay. So we don't have a clearly stated thing on the treaty, which says it's supreme law. We don't have a judicial decision. But alternatively, what you have is a protocol which wants to make the protocol above, which wants to make the national legislations above the protocol. When you look at the Vienna Convention on the Law of Treaty, Article 27 says that states cannot invoke their national law to avoid their international commitment. But what if this international commitment itself provides that the national legislation is going to be supreme over the international law? So what I have is, exceptionally, a treaty clause itself may provide in such a way that a treaty regime would be subordinate to the national law as far as that specific area is. I'm not saying that the overall, all of the national laws would be superior to that, the international law in general, but rather with regard to the matter that the treaty provides, with regard to those subject matters, the national law would be over the international law. So in this case, what we have is a protocol is saying that entry, exit, right of residence, and so on, things are laws which relate to those things, immigration laws, immigration procedures, and so on of the host member countries would be above the protocol. So that it shows that there is a refusal on the part of the states to accept supremacy of the treaty and the community law in general. Of course, to also to surrender part of the sovereignty. So one may ask then, if that is the case, what's the purpose of signing all those protocols, those treaties? If you are not willing to surrender our sovereignty, why do we sign treaties? Probably there's also an obligation of harmonizing the national legislations with the community law. So probably sometime in the future, through the harmonization process and so on, we may reach to a point. And then the other thing that I wanted to look at is the remedy which is available in the protocol. If, for example, if I traveled to one of the African countries and applied for a work permit or a residence permit, and the officer denied that, what remedies do I have? One of the first things it says is states have an obligation to set in place judicial and administrative procedures to hear complaints from decisions of customs officials. And again, on the natural person who's traveling from one state to another state, there is a requirement that the person has to exhaust the available local remedy. So it means I have to go to the either the administrative or judicial organ, which is introduced by the host member country. But there's no time cap. For how long am I supposed to wait for the officials or for the court to decide on my case? There's no time cap on that. In some of the treaties, I was looking treaties, not within the African framework, but other treaties. They suggest that there's a requirement of exhaustion of local remedies, but if the local judicial mechanism does not respond within a certain period of time, then there would be a presumption of exhaustion of local remedies. So that means if I go to court, I wait there the process takes about 6 months or whatever, depending on the time specified in the treaty, and no solution is provided on the part of the organ, then there's going to be a presumption that have exhausted all the available local remedies. It doesn't say that. It's only, the protocol only requires to exhaust local remedies, and then what if it takes, it lingers in the courts for an indefinite period of time, there is no solution. And again, once the local remedies are exhausted, the options that I have is to present my case to the African Commission on Human and People's Rights. That commission, it's a quasi-judicial organ. So it meets 4 times within a year. So the primary objective of that organ is not adjudication of cases, but of course it also has that mandate. So you can imagine how long it would take to decide cases. So far, in terms of human rights violations, cases have been brought before the Commission by individuals and by groups, and it's reported that the average time is 6 years. So it takes between 6 to 8 years to decide on applications brought to it by individuals. Plus, the reports, the findings of this body are not binding. They're just simply reports which are going to be submitted to the assembly and so on. So at the end of the day, if I'm not allowed to get a work permit from another African country, these are the options that I have, that we consider it as an effective remedy. I don't think that there is, this is an effective one. So when you look at this, the remedy regime that is provided in the protocol plus the previous slides, the discussion that I made in the previous slides, what we see is, yes, countries are signing, or the governments are signing the different agreements, but the assumption is that these are just political commitments, rhetorics that they tell to one another, and it doesn't look that they attach any legal significance to the documents. So at least for the time being, I'm doubtful that we can ensure labor mobility by looking only at this, the protocol. That's it.
So thanks very much. Now let's have a discussion. Thanks very much for the insightful talk. Yes, Christian.
Yeah, thank you very much. One question before